Next two slides I'll deal with quickly. Two options that a creditor has and the debtor has, frankly, to deal with foreclosures outside of the judicial foreclosure are the deed in lieu foreclosure or the voluntary non-judicial foreclosure process. Deed in lieu foreclosure really only works if there's no junior lien holders out there, because you won't be foreclosing any junior lien holders off. Their liens will still stay. You would just get a deed from the borrower. When you do a deed in lieu foreclosure without having to deal with any junior lien holders, there's no requirement that the debt be forgiven. So this could be done as part of a workout agreement. You can get a deed back to the property and agree that there's some deficiency that will be repaid by the debtor. You could allow the debtor some more time, or you could do a sort of the cash for keys proposal that's been done at times as well, where if you want to get them out because you want to get the property back and liquidate it quicker, maybe you'll give them some money to move out, some moving expense money or otherwise, to get to your asset quicker, to be able to liquidate it quicker. Eliminate some of the bank's holding costs, some of the attorney's fees involved in those sorts of things. Not that attorney's fees are bad. Other option, if there are junior lien holders and you have a cooperative borrower, you can use the voluntary non-judicial foreclosure requirements, and those are set out in 2148A. It's a pretty simple process. You get a deed back. The one thing you have to remember is that number one, you have to be in immediate possession of the property. If you do this, the creditor has to be given immediate possession of the property, and there is no deficiency allowed. So if you proceed on the voluntary non-judicial method, there is no ability to pursue a deficiency. Okay, so you're getting ready to pursue your foreclosure. What else do you need to do? And I would advise you to get a title report from the local title company. And it's kind of funny when you go around the state, they like to call them by different things. Title reports, open title commitments, ownership and encumbrance reports. You'll see them by any number of names. If you tell me you want to commence a foreclosure, most of them will figure out what you need and give you a report that gives you the name of the owner of the property. It'll identify the mortgage holders, judgment holders, property taxes, and any other liens that are on the property. When you commence your foreclosure, you want to name all of those junior lien holders. Hopefully, when you get the title report back, there's nobody that's senior to your mortgage, but you'll name all those junior lien holders as defendants. Some issues that I've seen come up when you get a title report, these small claims court clerks and the people that pursue claims in small claims court, they don't spend a lot of time figuring out exactly what their corporate status is. So you'll get a judgment that Tom's Hardware holds against the debtor. Well, who's Tom's Hardware? Is it a corporation? We punch it into the South Dakota Secretary of State's office. No, there's no corporation called Tom's Hardware. You call the clerk and say, who's Tom's Hardware? Well, that's Tom Johnson. Everybody knows that. So what we usually do in those instances is to determine that they probably are a sole proprietorship, call it Tom Johnson, doing business as Tom's Hardware, and plead it out that way. But it's a sloppiness that's out there and one you just have to deal with. I think you just have to do some due diligence to see what you can figure out about who they are. Another issue that comes up with some regularity is deceased borrowers or creditors. How do you get service on somebody that's dead? If they've got a personal representative appointed in the state, then it's easy to name the personal representative. If not, you're in the gray area as to how to get service on that person. We've utilized 2149, or we haven't utilized 2149-16. It seems to allow service on unknown heirs. I check with the title company by publication. It says I would check with the title company before you just publish and assume you've got service. We have appointed personal representatives, local attorneys, just for the sole purpose of serving process. That's seemed to work and pass title company muster. It's a bit more expensive and adds to your cost of the foreclosure bill. So after you get your title report, it's very important that you get the foreclosure commenced quickly, and here's why. Your title report will have a date that the title report was completed through. But a lot of times when somebody's getting their house foreclosed on, they've also got their credit card companies after them, they've got the medical bills after them, they've got the payday lenders after them, and those people are all kind of circling the wagon. Some of them pursue claims, some don't. But if you don't commence your foreclosure quickly after you get the title report, you might miss some intervening liens there and end up 6 months later when you get your deed to the property finding out that those liens are still hanging out there and you have to deal with them. So try to get your foreclosure commenced quickly, get your list pendants filed, and then that will place the name on notice. Yes, Jen?
Keith, once you record your list pendants and you think that your recordation of the list pendants and your service of the summons complaint tie pretty closely to your title report date, but indisputably or undisputably after you record the list pendants, there are essential liens that come in against the ground. Have you had any underwriters or title work people giving you trouble about the effect of your list pendants, the rule of law that your list pendants is there, and those people take subject to your foreclosure action? I always encounter trouble with that. Do you have a snap-out easy way for me to resolve that problem? Even when my list pendants is recorded, liens come in after that, that somehow they're not subject to my foreclosure action?
John's question, if you couldn't hear, is what if you get your list pendants filed and then judgment liens come in after that, then you get your foreclosure action commenced and move on down the road, you don't name those intervening judgment liens. John, at times I've done that. I've been able to tell the title company that the notice puts them on notice of the action.
I know.
They've not been buying it?
I've had a little trouble lately, but I think the fact of the matter is, I think we're both right, but I didn't know if you had the magic, maybe I don't have the right statute or something. It's in 1510, the answer's there.
Yes, I've got the list pendant statute, right?
All right, okay. Just check that.
Sorry, I don't have the magic bullet on that one.
All right.
So when you commence your action, obviously you have to commence it in the county where the property is located. If it's in more than one county, you can choose the county at that point. Name all the parties with an interest that are noted in the title report and get moving. Some quick hitters on how you go about naming individuals. For the United States, they're picky about how they're named. I think I have this right from prior experience. You list them as the United States of America, acting through the Internal Revenue Service or whatever agency you're dealing with. When you serve them, you send a copy to our local state's attorney, and you also send a copy to the U.S. Attorney General. You can send by certified mail. Note a CC of your letter to the U.S. Attorney General that it's going to the state U.S. Attorney as well, so that you have that clarified. Everybody knows you've done it, and provide an admission of service. The state of South Dakota is your defendant, then 1564D5 governs, and you need to send a copy both to the Attorney General and to the Governor's office. They're pretty good about returning admissions of service promptly, so I haven't had any trouble with that. In terms of commencing the foreclosure, I think it makes sense to attach the loan documents, redacting social security numbers for statute, of course. It's not required, but I think it just eliminates a step of discovery. If you're a debtor's lawyer, you'll have to see it, read and review the loan docs as well. If you're looking at it, that's the only way you're going to know what your client agreed to. Yes?
If a creditor's attorney is filing a foreclosure action and attaching the note, and they're representing one of those large banks which bought up bad loans from Countrywide and so forth, how does creditors' counsel go about determining that what they have in hand is the actual original note signed by the debtor?
Caitlin's question is when you have these large national mortgage lenders that have passed hands a number of times, the example is Countrywide, how do you know you have the note? I think you have to ask for the chain. I think you should say, well, how did this happen? And be able to demonstrate that. That's the best answer I can give you on that. It's certainly something that the debtor's attorney can ask for, and I think you're entitled to. If the name of the foreclosing lender is different than the name that's on the paper, you should be entitled to the chain how it got there.
Well, the most recent time I did that, the foreclosure is now stopped.
Because they weren't able to produce it?
Yeah.
Yeah. I think that's a fair tactic. Okay, so we're proceeding along. I did attach a draft complaint form in case you're interested in that. When you file your action, you file the summons and complaint, the notice of list pendants, which goes to the Register of Deeds. You file your notice of personal claim, which essentially says that you're not pursuing any personal claim. You want to send that to the junior lien holder so they don't think you're pursuing a personal claim against them. If you have no right to pursue the borrower for a deficiency or don't intend to, you can consider giving them one as well. Just a quick slide on issues that come up. Obviously, some of the common defenses, the amount of the debt, payment application issues, were all the payments I made properly applied? Was there a promise made of a refinance or renewal? All those things are things that can be litigated and addressed. Add to that list Caitlin's the suggestion on demonstrating proof that the proper lender is pursuing the claim. I think all those are appropriate things to be litigated. Showing my creditor bias, I cite you to the three cases that I think help creditors on summary judgment in terms of these defenses. If they're not really legitimate defenses and you're just asserting them for purposes of delay, then those are things that can be looked at. You know, and the other thing about it, of course, is in South Dakota, it takes a while to get a summary judgment proceeding. If what, as a debtor's lawyer, if what I really want is another 30 days for the person to stay in the house, I'd probably call the creditor's lawyer and say, hey, let's stipulate to the entry of judgment and just give us 30 days. Because half the time, if you call to try to get a summary judgment hearing, you're 4, 5, 6 weeks out anyway. Creditors' lawyers are going to say, go to their client and say, we can do it, we can press it through the court. It'll take us this amount of time, it'll incur these additional fees. I think you'd have pretty good luck talking most of your bank clients into stipulating to entry of judgment that lets them stay for another 30 days or stipulates that the judgment will be delayed 30 days. I don't see that as being a big issue. So rather than asserting a defense that might be a bit touchy, that might be a good idea. Okay, just a quick word on cure rights. Here again, we have a little statutory difference between our short-term redemption and our long-term redemption mortgage. On the long-term redemption mortgage, there is an interesting cure right at 2147(8). Anytime up until the judgment is entered, the borrower can come into court, come into the creditor, pay them the delinquent payments, the interest, the fees, and the costs, and cure the mortgage as if the default had never occurred and the foreclosure gets dismissed. There is no companion right under the short-term redemption mortgage statutes. Why there's that difference, I don't know, but there is. The other thing you might want to check, though, is there are some mortgage forms that provide for a reinstatement right. Usually it's down near the default provisions, and there's oftentimes in bold, they'll talk about the right to reinstate, and it kind of patterns the long-term redemption language. Proceeding along, say you've done your foreclosure, you get your judgment. There is a 30-day stay. Again, if the judgment is liquidated, it doesn't apply to default judgments. It does apply to summary judgments or litigated cases. I have had judges before, if the defense is a bit sketchy or perhaps not supported by the facts, I've asked them to waive that 30-day stay and have had judges determine that there was cause for that if the defense was not meritorious or the defense counsel doesn't even show up for the summary judgment argument, those sorts of things. I think would be grounds for cause to demonstrate that the 30-day stay shouldn't apply in the case. You get your judgment, you have to proceed then to the sheriff's sale and provide the notice of the sale. A little bit of distinction between the long-term redemption and short-term redemption. Short-term, you only have to advertise for 2 consecutive weeks. Long-term requires 4 weeks of advertising. Tend the sale. Obviously, we have outside of South Dakota attorneys doing foreclosures in South Dakota. And times I've been to sales, the outside attorneys don't show up. They just sort of mail in their bid. When I do things, I'm a little bit leery of just mailing in my bid. You don't know what's going to happen at the sale. You don't know who's going to show up. You don't know that the sheriff, not all the sheriffs out there do lots of foreclosure sales. They may not know what to do if somebody else shows up at the sale. So I like to show up or send a bank officer that I know has a cell phone and he can call me or he or she can call me and we can talk about any issues that might arise. But at the sale, the amount that you calculate for your bid amount will include your judgment, your post-judgment interest. I add the recording fees for my certificate of sale and the advertising fees for the notice of sale as well as the sheriff's commission, and that's my bid amount. Note, and this is a little bit of a goofy deal, but if the mortgagee bank bids, their sheriff's commission is $50. If anybody other than the foreclosing lender bids, their commission is calculated by statute. If you work through the numbers, if the bid amount is over $25,000, you have to add $1,036 to your bid to get the amount that they bid. Which, when you explain to some individual who shows up at the sale that he has to fork out another $1,000 over the bank's bid, they really don't like that. But that's the way it works, and in order for the bank to get paid in full, you have to enforce that. The sheriffs like it too. So. If somebody else shows up at the sale, which in my 15 years or so has happened 2 or 3 times, you do get people who show up, and there's more than enough to pay the foreclosing lender off. The statute provides a waterfall of how the expenses or how the proceeds are to be used. At the end, after all the debts that are owed to the mortgagee are paid, the funds are supposed to be deposited into the court for further use of the defendant or the person subject thereto, or entitled thereto, subject to the order of the court. So you end up with a situation where the court has to determine the amounts. I need to buzz along here. You fill out your sheriff's certificate of sale. I'm sure you've all seen those. You have a long-term redemption. Statutes have some additional requirements. For closing a long-term redemption mortgage, you have to do a return of sale and a confirmation. There's a confirmation process for the court to sign. Interestingly, I have seen some creditors' lawyers, mostly out-of-state guys again, using those provisions for short-term redemption as well. I don't think they're required. I've never had a title company tell me they're required, so I don't expend the extra money for my client to do that. Quick words on redemption. Here again, we have a whole bunch of statutes to talk about redemption. If you're talking about short-term redemption, you look at 2149, 33, and then in some of 2152, outlined there the people who have redemption rights. It is 180 days from the date of recording of the sale on a short-term redemption. Long-term redemption is different. Short-term is from the date of the sale. Or excuse me, from the date of recording of the certificate of sale on short-term. There's the amount that has to be paid. Pretty cut and dry. You pay the amount that the individual bid plus any amounts of interest or maintenance of expenses if they had to pay insurance or taxes or property preservation fees. Let me get to, okay, so the long-term redemption mortgage, again, they have 1 year to redeem. The 1 year clicks from the date of the sale, not from the recording date, the date of the sale. The interest amount is paid is different. In a short-term redemption, the amount to redeem is the amount of interest, or the interest rate as stated in the mortgage. I've never seen a mortgage that has an interest rate in it, so I assume that what the statute means is the note by that. On a long-term redemption mortgage, it's at the statutory rate of 10%. Why there's a difference, I don't know. But the process is generally the same. In a short-term redemption mortgage, you do have the opportunity, if your mortgage allows you to shorten the redemption to 60 days, if the property's been abandoned, that right does not exist for long-term redemption. Second position mortgages, I think there's a lot of seconds floating around out there for home equity lines of credit. You really need to assess your position. Where do you stand in terms of the first mortgage debt after liquidation costs? But if everything works out, you can foreclose subject to the first. Hope that the first doesn't commence foreclosure while you're doing it, which I've had happen. You commence your foreclosure with the second. If the first isn't doing anything, then the first commences their foreclosure, which just adds to their fees and costs because they're hired an attorney to proceed as well. But assuming you can get that, once you get your sheriff's deed, you pay out the first mortgage, and you own the property. Contract for deed foreclosures, it's a much simpler process. Instead of actually setting out a redemption period, the court establishes a date by which the debtor just has to come in and pay. Typically, it can be as short as 10 days. If it doesn't happen, the clerk enters a certificate noting that no redemption occurred, and then the property is invested in the contract vendor. The interesting thing I ran into recently on contract for deed foreclosures, we've always put the certificate at the end of our judgment. And the clerk pointed out that now that they're putting everything in image systems, they don't want to make any notations on anything that's already been filed. So you got to have two separate documents now, one for the clerk certificate and one for the judge. I am out of time. I'll certainly be around to take questions. I wouldn't want to cut into Mr. Schneider's time. Is there any introduction time?
Hi, Jim. Real fine, thanks. We have a variety of presenters, and that really adds flavor to the event. Jim Snyder comes to us from a long background in public service, been with the Assistant U.S. Trustee's Office since 1992, and has been helping also with the Office of the General Counsel and Executive Office of the U.S. Trustee's Office. Did that for a stint in 2006. Has acting experience, congratulations, acting AUST for the District of South Dakota for about 9 months now. So let's welcome Jim Snyder.
everybody's taller than me. As noted, I've been doing this a long time, long enough that I remember when Judge Nail had brown hair and when I had hair, and when I could give a presentation without a pair of reading glasses to see my notes. I started as a trial attorney with the United States Trustee's Office in Fresno, California in 1989, and I've been with the U.S. Trustee ever since. I have been the Assistant U.S. Trustee for the Southern District of Iowa, since we have two. Since 1992, I served a stint as the Acting Assistant United States Trustee for the District of Colorado for 18 months, and I've done a number of national projects with the agency. Since Bruce Gehring retired in December, I have been the Acting Assistant United States Trustee for the District of South Dakota. So, what does that mean? Well, partially it means that I got half of Bruce's responsibilities. You guys had the unique opportunity to have two judicial districts under one assistant U.S. trustee, the Districts of South and North Dakota, and I got South. If you're in South Dakota, I was the big winner. If you're from North Dakota, sorry, I lost out. So whichever way, I don't upset either of the two Dakotas. The way it's broken out right now for our offices, so you get an idea of how things work, I'm doing the District of South Dakota for all matters. I do the District of North Dakota for criminal matters and or certain supervisory matters related to our own personnel. We have one staff member remaining for the Districts of South and North Dakota, and that's Marcy Jones. Any of you who have dealt with our office over the past 10, 15 years know Marcy. Marcy is still there. Marcy is hanging out at the office. Unless she's on her telework day, you'll find her there. If you need to reach the office, you can always call the main number. Marcy will answer it, or it will be forwarded to her wherever she is. And Marcy can get in touch with anybody you need to. If it's a North Dakota matter, you're going to get bounced off to Robert Ratchke, who's the Assistant U.S. Trustee from Minnesota. They're handling everything out of North Dakota. If it's a South Dakota matter, you're going to get stuck with me. And I will give you my direct number in Des Moines is 515-284-4985. That should ring directly into my office. We're getting a new government-wide phone system next week, so a week from then, it should ring directly into my office, and the phone might actually be working by then. So if you need me, that'll get a hold of me. Otherwise, contact Marcy, and she will get a hold of me. For those of you, I know there's a few experienced bankruptcy practitioners in the room, because I recognize a couple of them. If I recognize you, you've got to be an experienced practitioner, because I haven't been here very long. So for me to have seen people more than once is pretty rare. We have 3 trustees now in the District of South Dakota. One of whom, at least, is sitting in the back row. That would be Leanne Pierce, who is a Chapter 7 trustee out of Brookings. If you file a case that comes into Sioux Falls, it's Chapter 7. Leanne is going to be your trustee. The other Chapter 7 trustee is Forrest Allred out of Aberdeen. If you file in Aberdeen, Pierre, or Rapid City, you're going to get Mr. Allred as your Chapter 7 trustee. There's also a Chapter 12 and 13 trustee. We're happy that that's the same person. That's Dale Wine, also out of Aberdeen. Any 13 or 12 that you file is going to be assigned to Mr. Wine. Ultimately, all those people end up under my, and I outlawed air quotes in my office, so I won't air quote the word supervision, but they will fall under my supervision. We like to think of it more as a partnership. I get more good information from Leanne and Forrest than I ever give to them. So it's a partnership. It's more of a one-way deal right now. I'm getting an education on how things work in South Dakota, and I'm getting great case referrals from my trustees. So let me give you an idea. If you're new to the bankruptcy world, especially, let me give you an idea of what the U.S. trustee does. We are, the defined term is the watchdog of the bankruptcy system. I do so hate that term that I hesitate to use it, so I'm not sure what a watchdog is supposed to do. I can tell you the premise. The premise was that under the referee system that judges in the bankruptcy process were too involved in the administration of cases and not enough like real judges. So what Congress sought to do was make the federal bankruptcy judges on par with the federal magistrates. Judges who decided issues that were brought before them by parties, not referees who raised their own issues and then decided on them. Congress sort of thought if the judge brought a motion against you, you were likely to lose, and I still think that's probably pretty good reasoning. So the concept was to break the system up. Now, if you broke the system up, then they needed somebody to administer the bankruptcy process and to raise issues before the court. in areas where the parties will not be active, hence the U.S. Trustee's Office. And that's really my job. My job is in certain areas of the code to bring issues before the court and to let the court decide those issues. We also supervise the trustees, and we deal with certain issues, administrative issues related to case closings and some other ministerial things that went on. But to a great extent, my job is to simply be a party in interest in the case under certain specified code sections to bring matters before the court's attention. I'd like to think we're pretty good at that. I would also like if you guys would get busier and file more cases so that we have more issues to bring before the court. We're a little short on cases right now, but and I feel bad if I'm in a public setting hoping for a bad economy and more bankruptcy filings. So I'll hope for a good economy and more bankruptcy filings. I'm just hoping for more bankruptcy filings because it's how I make my living, and it's a little light right now. And when we get light and budgets are under constraint, then Congress starts looking at places where they can cut, and if you don't have any cases, we become one of the areas that can get cut, and that makes me uncomfortable. So, those areas that I talked about where we are likely to be involved in the bankruptcy process, or where you're most likely to see something from me, we'll start out with 109H, credit counseling requirements.